Good evening, viewers. Welcome to the Personal Injury Law Show. This is the show that we talk about everything to do with personal injuries, workers' compensation, transport accident matters, insurance matters. My name is Don Maffia. I'll be your host tonight. With me tonight, I have John Karantzis, a partner at a law firm.
Hi, Don. Hi, viewers.
And I also have Alistair Boughton, a lawyer at a law firm specialising in transport accident matters.
Evening, Don. Evening, viewers.
Don, before we get into the show tonight, which is about transport accidents, what's in the news?
Well, John, we're going to talk about Essendon, drugs, and the federal court.
Don, the federal court heard allegations, sensational allegations, Don and Alistair, testimony from James Hird about he being coerced into signing a settlement, a compromise of the matter. Now, Alistair, it was all sensational, but what does it come down to?
Well, the arguments that Essendon have been raising in the federal court relate to a lack of jurisdiction and a lack of procedural fairness.
From ASADA?
From ASADA. So they're essentially disputing the process of the ASADA investigation.
They're not disputing the actual evidence. They're just saying procedures weren't followed, protocols were not followed, and the AFL and ASADA were, in essence, working together, which they say it's alleged that they shouldn't have been, and therefore, my understanding is all the evidence should be chucked out.
Well, just for the viewers, so this is where ASADA has investigated we can't even say alleged, a drug taken from the Essendon players. A report was commissioned. As a result, there's been 32 show cause notices on the players. So this application is just to try and get that investigation. Therefore, the show cause notice is set aside on the basis that it was unlawful investigation.
The evidence from James Hird, very sensational, wasn't it, Alistair?
It's incredible. He has essentially said that he was coerced into initially being involved in the investigation.
So let me get this right. He was coerced in taking $1 million and taking 1 year off, 1 year off from playing AFL and living in France. He was coerced to do that.
And undertaking an MBA. But it was he took that deed of settlement under great threats, duress and inducements.
Okay, well, the inducement, I take it, being the $1 million he was paid by the Essendon Football Club. Yeah. So why isn't the allegation against the Essendon Football Club then? Well, anyway, I'm finding it hard to understand his legal allegations. Yeah. In the end, we now have the federal court that has to come up with a decision, don't they? The justice will come up with a decision whereby he could either chuck out all of the charges or say, no, the investigation was valid. The AFL and ASADA can act together and investigate a team, in this case, the Essendon Football Club. Any other alternatives?
Well, John, let's say that the Justice Middleton says it was an unlawful investigation. What happens next? Can ASADA just reinvestigate and issue a show cause notice? Because Essendon have self-reported. They said that happened in the club.
Well, ASADA have made it clear they will simply reissue the notices and rely only on the evidence that they obtained from thereafter a certain date. So what does that mean that the Ziggy Switkowski report, can that be now used or not used? It's very complicated, isn't it?
What we do know, it is bringing the whole game, I was saying, disrepute.
Alistair, you've got a different take on this, haven't you?
Look, it does seem like this legal proceeding launched by Essendon is smokes and mirrors, hiding the real issue, which is whether the players took performance-enhancing drugs. And I'm surprised that parallels haven't been drawn between what Essendon have done and what Lance Armstrong did in relation to cycling. Over in the USA, Lance Armstrong launched proceedings in the equivalent of the US federal court, asserting that USADA didn't have jurisdiction to make the findings against him for anti-doping.
So this is exactly the same scenario as what we've got here now.
Well, there are obviously slight differences, but the legal principles involved are virtually the same.
And what happened in that case?
In that case, Lance Armstrong's proceedings were dismissed, thrown out, and 6 months later he was on Oprah Winfrey confessing to doping for his 6 Tour de France wins.
And Alistair, that's where Lance Armstrong was charged with perjury, because during those federal court proceedings, having admitted that he's taken drugs 6 months after those proceedings were dismissed, he went back and was found to be lying during those.
He was charged with perjury, and there was also criminal investigations into his conduct, but those criminal investigations were eventually dropped.
Yeah, John, you have all these Essendon players which were taking these, were administered these performance-enhancing drugs. As yet, we still don't really allegedly. As yet, we still don't know the full extent what it was and all that.
No.
If the players' bodies are affected by this or have sustained an injury, what are their rights? Do they have workers' compensation entitlements?
Well, under the Victorian work cover laws, no. They're excluded from workers' compensation in Victoria. However, they will have rights under public liability, under the Wrongs Act. However, the statute of limitations of 3 years will kick in once they're aware of bodily damage that they have suffered. So that is going to be interesting to see. Well, the question will be, when are they, or when will they be aware of something occurring to them? But every football player has a right to sue in regards to bodily damage for a drug that they have been administered with or without their knowledge.
Yeah. And well, obviously we're hoping that doesn't occur, but the players are getting legal advice about these show cause notices.
Exactly.
As far as we're aware. Now, we'll definitely come back to that. Definitely once the decision's handed down by Justice Middleton, I'm sure we'll do a whole segment on that.
Yes.
Now, just quickly, before we go to the break, there's another article I want to go to. This is the police nab a donut. Alistair, what's that about?
Apparently, police were involved in a donut eating competition involving some members of the public, and were beaten by one particular member of the public.
And this is in the United States, isn't it?
It's in the United States of America, of
It can only happen there.
Only in America.
Tell us.
What eventuates is that the winner of the donut eating competition actually had a warrant for his arrest out, and by virtue of him winning the donut eating competition, police have been able to identify him and arrest him.
And how many donuts did he eat?
I've got no
it's
idea.
eight donuts.
8 donuts.
In 2 minutes.
In 2 minutes, John.
I'm sure I know people that can do better than that.
But again, I think that's only in America. Now, viewers, after the break, we'll go into a few TAC case laws, transport accident case laws, so stay tuned and we'll see you soon. Welcome back, viewers. Now we're going to be talking about a few TAC or transport accident case law. The first I'm going to talk about is irrational or unexpected behaviour of pedestrians in the case of Johnson and Stock. Elsa, tell us the facts.
The facts are quite interesting on this one, Don. What's occurred is it's been the early hours of a night out for two individuals. One was a pregnant woman who is driving home from a social occasion. The other is a pedestrian who is clearly intoxicated, and is stumbling towards the road. Now, the pedestrian gets to the road and pauses. The driver of the vehicle, which is being driven by the pregnant woman, observes the intoxicated pedestrian pause at the side of the road, continues on, slows her speed, and then out of nowhere, the pedestrian takes a couple of steps onto the road, apparently didn't observe the vehicle, and there is a fairly serious accident that occurs.
Was there a suggestion she was speeding?
There's no suggestion that the driver was speeding. In fact, it was a marked 60 kilometre per hour zone, and the driver slowed to approximately 40 kilometres per hour as she approached the pedestrian.
So how did the accident occur? That's what I'm trying to work out.
The pedestrian actually walked into the car.
Yeah, but...
So she stopped on the side of the road. The driver thought that the pedestrian saw her and was giving her way, effectively.
Okay.
It wasn't a pedestrian crossing. It was just a section of the road where a pedestrian could cross one to the end. And she proceeded through, and as the driver proceeded through, the plaintiff took 2 steps and walked into the car.
So in other words, he was that intoxicated, he didn't realise he was walking along.
Well,
okay.
the defendant in this matter, the driver, said that she saw the plaintiff walking in a zigzagging and stumbling on a footpath. This is before. Now, the plaintiff's BAC's levels, so blood alcohol concentration level, at the time of impact, she was 0.03, which equals, or she drank 8 stubbies of mid-strength beer and 1 shot of Sambuca.
Don, I think the court found that wasn't quite believable, and that it was far more than 8 stubbies of mid-strength beer. And there was some discussion that for people who are not tolerant of alcohol, the level of her BAC was almost at fatality level.
Yeah. So the pedestrian stopped, according to the driver, looked at the driver, and then the driver thought, okay, well, she's going to let me through.
In any event, she's now issued proceedings for compensation for the injuries she sustained.
That's correct. And at first instance, what happened, Alistair?
At first instance, the judge found that the driver was negligent, and therefore the pedestrian could recover compensation. However, the pedestrian was 75% responsible for the accident occurring.
Now, but what's interesting, Alistair, is why did the trial judge find that the driver the driver slowed down, saw the pedestrian? Why did the trial judge find that she was negligent?
The trial judge found that the driver failed to properly identify herself by failing to flash her lights, toot her horn,
move more to the right.
Further to the right to avoid a possible collision occurring.
And John, it was appealed. Surprisingly, it was appealed.
It was appealed to the New South Wales Court of Appeal.
Correct.
And we've got a different verdict, haven't we?
Yep. Now, the verdict was the 3 judges of the Court of Appeal overturned the trial judge's decision and said there was no negligence on the part of the driver.
That's correct, Don. The analysis of the judgment suggests that the court took into account the fact that the driver did observe the pedestrian approaching the footpath and slowed her speed, but also observed the pedestrian look at the driver. Therefore, the court found that why would the driver need to flash its lights, toot its horn, or move further across in the lane when it's of the view that the pedestrian has seen it?
So, effectively, the driver is really not held liable, cannot be found held liable for the irrational, unexpected behaviour of a pedestrian. She thought the pedestrian was going to stay there and wait for the car. But obviously the pedestrian didn't, took 2 steps and hit the car.
So even if there's an intoxicated person on the road, that doesn't necessarily change the duty of care.
I wouldn't think so. I mean, it's a standard of care to take care. So take reasonable care. The driver did everything. She slowed down. She didn't toot her horns or didn't flash her headlights because she observed the pedestrian standing on the side of the road and giving direct eye contact with her, thinking it's okay for me to pass.
Don, what about if she didn't do that and she drove at 80 miles an hour?
Then it wouldn't have been a court of appeal. The decision of trial judge would have been correct. I would have put more apportionment on the driver. I wouldn't have found so high to the pedestrian for contributory negligence, but the driver will be at fault because you have to take care. You have to keep an eye out for what's going around your surroundings. So, if you see a person walking down the street, stumbling, zigzagging, there's a good chance that the pedestrian is going to cross the road.
And we're talking about what the reasonable person in the circumstances would do.
That's correct.
And the court found in this instance that, well, she acted reasonably.
Well, I guess, Alistair, what more could she do? She slowed down and
observed the pedestrian look at her. And a reasonable person would not expect a person to step out in front of a car knowing that the car was coming.
Again, what about if the driver knew that that pedestrian was drunk?
In New South Wales, the Civil Liability Act says intoxication has no effect on the standard of care, so it wouldn't make a difference. The story might be a little bit different in Victoria. You'd have to refer to the common law.
It'll just be, in my view, in the circumstances, John.
Yeah.
So if you see, like I said, if you see a drunk person, you may not know the person's drunk, but the way they act or irrational behaviour, then you've got to take care. And I think she did take care. Look, it is definitely a harsh decision on the plaintiff. We like to see plaintiffs win, but unfortunately in this case, I think it's the right decision. What do you think, John?
Yeah, no, I agreed.
Alistair, right decision?
I agree. I don't think you can find liability against a driver that's slowed down in those circumstances.
The next case we'll talk about is Bogdana Lakic and the TAC. It's a case that was run before His Honour Jack Rush from the Supreme Court of Victoria. In that case involved all issues. We'll talk about the facts after the breaks. So stay tuned, viewers. Viewers, welcome back. We're talking about updated TAC or transport accident case law. We're going to talk about the case of Lakic and the TAC. Alistair, you want to tell us the facts about that?
Very interesting case, Don. As you mentioned before the break, it's got everything in it. It involves an accident that occurred with an unknown vehicle. Miss Bogdanka Lakic was driving her motor car when a motorcyclist behind her appeared to be playing games with her, has overtaken her and cut her off, which has caused Miss Lakic to lose control of her own vehicle and run off the road and have an accident causing fairly serious injuries, she alleges. Those injuries were disputed. There wasn't much on radiological investigation, so x-rays and scans didn't produce anything. And the TAC produced video surveillance suggesting that she may have been putting her injuries on or exaggerating her injuries. But the body of medical evidence found that, in fact, she did have fairly severe injuries.
So Alistair, she suffers this transport accident in 2000, the year 2000. Mm-hmm. Then she has a further transport accident in 2001, and then another transport accident in 2006. Now, she's gone to court asking the court to grant her a serious injury certificate and damages payment for the injury sustained in 2000.
That's correct. So the plaintiff argued that her main injuries were from the first accident, not the subsequent accidents. The issue was that in the first accident, the motorcyclist was never identified. The motorcyclist drove off and police never found out who that motorcyclist who allegedly caused the accident, who that person was.
Now that brings me on to what's the procedure in Victoria. So there's a lot of issues here. The first one is unidentified vehicle that's caused, or driver of a vehicle that's caused an accident. So in Victoria, the TAC is liable to identify the unidentified vehicle or driver, but there are provisions that say you must put TAC on notice, John.
Within a short period of time.
Within a reasonable time.
Yes.
Now, usually the way we do it is we send a form to the TAC saying, unidentified vehicle, do you know who it is? We don't know who it is, and TAC look in their records. She didn't do that, but she did something else.
What she did do, Don, was complete her TAC claim form and filled out all of the relevant details on that TAC claim form, including where the accident occurred, what time the accident occurred, the circumstances of the accident, the fact that police were called, and what her injuries were arising from that accident.
So I think within a matter of a week or so, she put that claim in, and the judge accepted that's sufficient to satisfy that provision that you must put TAC on notice. So judge won that. The judge liked that. The next issue was, John, consistency on how she described the events. And this happens very often when we run these type of matters.
Yes, it's the plaintiff, in this case it's Mrs. Lacic, goes to all these doctors, treaters, medico-legals, and she's a Bosnian-born woman, 33 years of age. English is not her first language. So what we have is varying accounts of the injuries, how the injuries occurred, and the impact of the injuries upon her. Now, the Transport Accident Commission, at the hearing, jumped on that and tried to make it out that, there's inconsistencies here. It's not all the same story, therefore, something's not right.
But Alistair, what did the judge say in those circumstances?
Well, the judge said that the contemporaneous evidence was consistent with her story at court. So what Miss Lacic reported to police who attended the scene and what she told police in terms of how the accident occurred was consistent with what she said at court, and therefore the court accepted that version of events.
And following from that, so the judge found that the accident was caused by the negligence of the unidentified motorcyclist.
Yes, in the first transport accident.
That's
in
right.
2000. Because the plaintiff here, Mrs. Lacic, had a big problem, didn't she, at trial? She had to distinguish and differentiate the injuries she sustained in 2000, 2001 and 2006. It's a really difficult prospect, isn't it?
It is. But look, she succeeded, John, because a lot of her doctors did support her.
Exactly.
Since the first accident, she was a worker. She worked for, I think, many, many years as a packer since 1997 at Arnott's Biscuits.
Yes.
And she never went back to work since the first accident.
Yes.
And she went to a doctor and kept complaining to a doctor. Now, the other issue was, which, John, surprisingly, and Alistair, is that the TAC raised or alleged contributory negligence against her. So saying she's contributed to the accident.
That's right, Don. What the TAC alleged was that she, in the circumstances she described, she was cut off by the motorcyclist. And the TAC alleged that a reasonable person would have applied their brakes and would not have lost control of their vehicle because the motorcyclist was travelling a lot faster than her. However, the court found differently. The court found that a reasonable person would in fact have swerved to try to avoid the accident, and it's reasonable for a person in those circumstances to swerve.
John, what's your view about raising those issues of contributory negligence in these circumstances?
Look, to be quite frank, it was a bit of a stretch. However, we know that's how these legal cases work. But I think in the circumstances, well, the judge clearly saw that she acted appropriately and reasonably.
Now, the next issue was the DVD surveillance. Now, John,
This
we
happens
know, Alistair, this happens quite often.
in
We
every
spend a lot
trial.
of time- Every trial.
Every trial. Work cover, the Transport Accident Commission, any insurer will try to obtain video evidence, video surveillance footage of the plaintiff basically doing things she or he says they can't do. Now, in this instance, it was showed to the court, but Alistair...
Well, the DVD evidence showed the plaintiff attending the park, getting on a swing and being able to move herself on the swing quite freely. The court found that she did in fact have freer movement and less restriction than she had reported to doctors, and that as
So
a
the
result
judge-
she exaggerated her symptoms.
The judge found there was an exaggeration,
Exactly right.
but it wasn't fatal.
It wasn't fatal to
Wasn't
her
fatal
case
to the
because
case.
the judge found that whilst there was an exaggeration, there was still a very severe component to her symptoms. She moved very slowly and was still restricted in her movement.
But more importantly, every witness that gave evidence, her doctors, her family, relatives, there was a few witnesses, all showed how this has affected her.
Exactly.
So the evidence swayed to her being severely injured.
And that's really important in all these cases, isn't it, Don?
Yes.
You need witnesses, the plaintiff needs witnesses to back up their story.
Exactly.
Independent witnesses, family, friends, co-workers, to show what happened and how it impacts on you.
And from doctors as well. So before I wrap up, judgment was for how much, Alistair?
Judgment was for the plaintiff for $247,000 pain and suffering.
Yep.
In addition to that, the court awarded $334,000 for past economic loss and $256,000 for future economic loss. The total amount awarded was $838,000.
Fantastic result.
And John, there was an allowance by the judge, I think about around the 10% mark for the other accidents. So 10% of her damages were from the subsequent 2 accidents. So John, any final words before we wrap up?
These trials are very costly. That's a great result by Mrs. Lacic, but after a 2-week hearing, the court fees, the legal costs are enormous.
Exactly.
And Don, what I can say is anyone involved in a transport accident, in a work cover claim, you need to speak to the right lawyers. Here at Nowiki Carbone, we are specialists in personal injury law and litigation. We are able to help. Please give us a ring.
And Alistair, most importantly, always seek legal advice.
Exactly right. And you may not think that you have a claim because you can't identify the other driver. That's not the case. Just because the other driver might disappear and not stop at the accident does not mean that you will not have any rights.
Well, thanks, John. Thanks, Alistair.
Thank you.
Thank you, viewers. Stay tuned for our next episode. Please go onto our website or go on Facebook or Twitter and look at our past episodes.